On behalf of Jones Day, we'd like to welcome you to How to Develop a GDPR Compliance Program. This program is scheduled to run from noon to 1 p.m. Eastern Time. If you're having difficulty hearing me, please check to make sure you have the volume on your computer turned up all the way. If you have any other technical difficulties, please contact the Beacon Live Help Desk at 1-877-297-2901. Also, if you've not already downloaded a copy of the CLE Credit Information Sheet, you may do so from the Handouts tab on the left. A copy of the presentation materials will be emailed to you after the webinar. This presentation has been approved for CLE credit for attendees. The CLE Credit Information Sheet provides you with information regarding the available credit. Applications for CLE credit in other states will be made as needed. Please keep in mind that CLE credit is not available when viewing the on-demand version of the webinar. There are several important steps that you must take to demonstrate that you are actively participating. First, each participant must have registered individually for the webinar in order for your time of attendance to be recorded. If you've not individually registered for this webinar, please do so immediately by contacting Wendy Sung at wendysung@jonesday.com. Second, at various points during the webinar, a box will pop up on your screen asking you to confirm that you are viewing the webinar. You have up to 1 minute to confirm your participation. If you do not confirm each time the box appears, you will be denied CLE credit. Third, you must be logged in for the entire presentation or segment, otherwise the CLE credit will be denied for that segment. Within 24 hours, you will receive a link to generate your CLE certificate. If you do not receive the email, please contact the Beacon Live Help Desk or email cesupport@beaconlive.com. It is mandatory that you enter your bar number. If you cannot locate your bar number, please contact the Beacon Live Help Desk for assistance. You will be in listen-only mode throughout the presentation. If at any time you have a question, you may submit it through the chat window located in the lower left corner of your screen. We will attempt to answer those questions at the end of the webinar. Now, with those housekeeping items out of the way, I'd now like to turn it over to our speakers for the live presentation.
Hello and welcome, everyone. My name is Jörg Ladig. I'm leading you today through this webinar in the series of our webinars on the EU General Data Protection Regulation. Some of you may have joined us already last week, where we started our series. Today we have the topic of how to develop a GDPR compliance program, and for that purpose I will be joined by a number of my colleagues in our team, Ondine Fatima in our Munich office, Olivier Haas in Paris, and last but not least, Jonathan Little in London. So what we will try to do today is very practical compared to last week, but we thought it is very useful for you to understand a practical approach, how to set up a compliance program, or to compare even if you have already started a program within the organization for GDPR compliance. Maybe you can take away some of the recommendations from us today. So we have quickly a slide on the agenda. You will see this is the order of how we will go along with the speakers today. We have picked a 4-phase plan as the approach, being very well aware that there are different methodologies how you can run a GDPR compliance project, but we discussed this in the team and we all felt that any kind of methodology probably has 4 main phases in a project. So we will go with these 4 main phases you see here on the slide: fact gathering, then gap analysis and follow-up, then some words about prioritizing, mitigating steps for compliance recommendations, followed by a practical approach, main steps, how to comply, how to implement compliance. And then we will have 15 to 20 minutes of a Q&A session for you reserved, where we would really much like a discussion, a dialogue, and hear from you what are your questions that you may have for us and how we can help you understand some of these items. And with that overview, I hand over to my colleague Undine van Diemen to talk about phase 1, fact gathering.
Thank you very much, Jörg. Yes, phase 1, fact gathering, is really the phase of a GDPR compliance project where you lay the foundation, so to speak, for the success of the project. This is really to establish the lay of the land in terms of the compliance posture of the company. And the first relevant step is to review what you have in terms of existing data protection compliance information. And one very helpful resource are registrations, existing registrations with European data protection authorities. Remember, under the currently applicable European Data Protection Directive, there is an obligation existing to register data processing activities with the authority unless a DPO has been appointed. So countries like France or Belgium know this requirement very well. And this registration should inform you, for example, about the name and the address of the controller, about the purposes of the processing. It should contain descriptions of the categories of data subjects and the data categories processed. Also, recipients of the data should be mentioned, and very important, whether any data transfers to third countries, i.e. transfers outside of the EU, are happening. And the registrations should also contain a general description of the technical and organizational measures taken to secure the processing activity. If you compare that list with the items, with the information required under Article 30 of the GDPR as records of processing activities, you will find it's pretty similar. So this is a great help to also fulfill this GDPR obligations. Another valuable source of information are existing data processing agreements. So you can see the data recipients because you have a list of providers. Also, the data processing agreements will inform you about the technical and organizational measures taken by the provider. Data transfer agreements, like for example standard contractual clauses, will also inform you about data recipients. They will also give you information whether a data recipient acts as controller or as processor, which is relevant. And in case of controller-to-controller transfers, they will inform you about the purposes of the processing activities. The data transfer agreements, like standard contractual clauses, also contain information about the data subjects whose data are processed and about the data categories processed. And in case of standard contractual clauses for processors, they contain, similar to data processing agreements, a description of the technical and organizational measures taken. Data inventories can be helpful, although they are often drawn up from a technical point of view, though they are often application-based and not so much drawn up from a data protection point of view. But they might contain information about data sources and also the business owners for a certain process, which can be helpful in the organization of the project. Data flow maps, depending on the level of detail, will at least provide information about location of the data processing, and this can be relevant, especially to determine cross-border transfers. IT or IT procurement specifically might have a list of the third-party providers a company is using, and this can be a good starting point to determine not only the data recipients but also the various applications used. What if only very little or even none of the above of this information mentioned is existing at a company? Well, then I would start probably very simple and maybe circulate a questionnaire among the relevant parts of the organization, in particular HR, IT, and marketing. And I found actually that the Information Commissioner of the Isle of Man provided on his website a quite helpful GDPR mapping toolkit, at least as a starting point, if nothing else available. And this toolkit contains basic guidance and also a questionnaire in order to address the basic 5 W's of data mapping, which is: why is personal data processed? So this is about the purposes of the data processing. Whose personal data is processed? This is about the data subject categories. What personal data is processed? This is about the categories of the personal data process and the source, and maybe also the legal basis, which includes, for example, consent. When is personal data processed? This is about when data has been obtained and to whom it has been disclosed, and how long it is retained. The last W is: where is personal data processed? And this is about the location and also in which processing systems the data are processed. So again, as mentioned, this is helpful as a starting point if not much information is available. Another important part of phase 1 is actually holding conversations with really key members of the company. This includes IT, HR, marketing, of course also legal and compliance. And this will help you to get a better understanding of the company's data protection and security-related practices, and also the technical controls. And in terms of the technical controls, it's probably interesting to find out whether your company is maybe also in the process of obtaining an ISO certification. In particular, ISO 27001 can be very helpful to also address GDPR requirements, because there is an overlap between the controls that will be implemented for ISO 27001 and the controls that need to be implemented to address the data security obligations under the GDPR. Another relevant step is taking into account the recording requirements under the GDPR. As mentioned, Article 30 of the GDPR requires a controller to maintain records of processing activities. And the information that needs to be gathered is pretty similar to the information that needs to be gathered or has been gathered for registrations with data protection authorities. What is new under the GDPR is that also processors are obliged to maintain records of processing activities. And phase 1 is a good point in time to start with creating such records. And this means that you should determine a process for collecting this type of information, and also establish a process to maintain such records, because they need to be current all the time. This includes also the selection of a suitable mapping tool. For smaller companies, an Excel file might be sufficient, but for bigger companies, there's probably either a need for an own solution, or maybe the solution of a vendor. So what are the key objectives of phase 1? I think the first objective is really to obtain all the necessary information to get a full understanding of the company's current compliance posture, and then compare it against the most relevant requirements under the GDPR. And again, the information necessary for creating the records of processing activities under Article 30 GDPR is here a very helpful benchmark, because this information is relevant to address various obligations under the GDPR, which includes answering data subject requests and also ensuring notice and consent obligations towards data subjects. A second objective is then to identify any gaps in information that is needed, especially that is needed in order to perform the legal gap analysis under phase 2 of the project. How long will this exercise last? I think this is a bit of a tricky question because the answer depends very much on the pre-existing information and also on the timeliness and the quality of the information that you are able to gather during phase 1. So I would say that phase 1 of the compliance project usually takes approximately 6 to 8 weeks, but of course filling the gaps of information needed might take longer, and it might happen during the following phases of the project. So there's, from my experience, no clear cut after phase 1 in terms of the fact gathering. So what about phase 2, which is the legal gap analysis? Olivier, would you please take over and let us know?
Sure, Andina. Many thanks for a kind introduction. And now I would like to talk a little bit about phase 2, which is indeed gap analysis and follow-up. As a preliminary note, and following Indina's introduction to the fact-gathering phase, I would like to insist on a key point, which is that during the fact-gathering phase, it is really key to gather sufficient factual information in order for the second phase, the gap analysis and follow-up from a legal perspective, to take place. And what is important there during the fact-gathering phase is to ensure that the different contact people that you will be interacting with and who will provide you the technical information do not start providing you with some legal analysis, legal assessment, or consequences of the technical information they will be providing to you, because otherwise that might create bias on the legal assessment, which is the whole purpose of phase 2. So on the basis, again, of the really factual analysis, factual information collected during phase 1, the phase 2 will focus on assessing the legal difference, the gap between the status quo of compliance with respect to the data protection regulations applicable in your jurisdiction and the requirements pursuant to the GDPR. So that means that with respect to the current status of the regulations in your jurisdiction, you will have to see what new and additional requirements are imposed by the GDPR, such as, for instance, as in respect of the information or data subject, the additional pieces of information that will have to be provided to the data subject, or in terms of documentation, the creation of the records of processing activities that are now required under the GDPR. And also, for instance, with respect to data processor agreements, the additional requirements for mandatory clauses in the agreements with data processors. So this is really, again, the very objective and analysis of the additional legal requirements resulting from the GDPR with respect to the current regulations applicable in your jurisdictions. And then, on the basis of this, the identification of these additional legal requirements, you will have to determine which additional requirements are really applicable to you, to your business in your jurisdiction, and relying obviously on your past experience and existing work products, because they hopefully such products resulting from previous analysis with respect to current state of data protection will be a great starting point to improve your status of compliance with respect to the requirements of the GDPR. So when it comes now to summarizing a bit the key objectives of phase 2 gap analysis and follow-up in respect of setting up this GDPR compliance program, again, the first key objective is to perform the legal gap analysis and to identify the areas of concern in terms of compliance with the new increased requirements resulting from the GDPR. A second step will be to identify in practice for your business the compliance actions and remediation measures that are required in order to get closer to compliance with the GDPR, and also to develop a risk ranking with respect to the different compliance action items that you will have identified during this gap analysis in phase 2. Then, once you've identified the practical measures, remediation measures that are necessary to reach compliance, you should definitely assign tasks and develop a timeline identifying key roles and responsibilities within your organization in order to address the gaps and recommendations that have been identified. And then one of the follow-up tasks will be to assess the legal efficiency of operational and technical measures that are recommended by your business contacts in business operations and that are proposed in order to address the compliance gaps that have been identified with respect to the compliance requirements for the GDPR. In terms of timeline, we would say that the time necessary to complete this phase 2 gap analysis and follow-up typically takes at least 4 to 5 weeks. And now with that, I'll hand it to Jörg for the next topic.
Yes, thank you very much, Olivier. So we're moving slowly but surely to the next phase in your potential compliance project for the GDPR. Phase 3, we call it prioritizing mitigating steps and recommendations. So what do you have to look out for in phase 3? Obviously, based on what Olivier just explained in terms of the gap analysis, it will be very important in the next phase to get an idea and prioritize any kind of compliance measures that may be relevant for compliance with the GDPR. And as we all know, in compliance, there is obviously a range of measures you can implement depending on the organization, the appetite for risk and compliance. You can do an approach that covers minimum requirements versus a gold standard. Some people call it that. And there's probably some other flexibility, a range in between. At the same time, we feel the GDPR makes it much stricter for certain requirements, so the flexibility may be a bit more restricted with GDPR compared to other compliance measures. Anyway, what is important in phase number 3 is to ideally have some meetings with company stakeholders. Why? Because phase 3 will also be mainly about having a risk assessment done in the organization to make sure that any kind of compliance steps are taken by consideration of stakeholders in the organization, in different departments, what the goals are, objectives are in terms of compliance. And then a cornerstone for that phase 3 is to develop, if you want to say, an executive report, summary report on GDPR compliance that starts a little bit with the results of the gap analysis that Olivier has outlined nicely, and then talks about these various steps that you may consider for mitigation of risk and compliance. And here, I think the risk assessment should take an important, prominent role. Why? Because obviously, every organization is different in terms of the business model. So the types of data that the organization may or may not process is different. The purposes for which you do process personal data is different. So depending on the type of company, the business sector you're doing your business in, that risk assessment has an impact on how you basically shape and define your compliance measures. The report can also include recommendations based on that assessment. You can then, you see the word timeline popping up all the time, here even twice on the slides. Apologize for that. But that's important to always be clear about timing to meet expectations. We all know, in theory at least, companies have to be in compliance as of May next year, which is not really a lot of time left, and we will touch upon that later as well. think about some risk ranking if you can do it for certain action items that you may have in mind, and then also include in the report for management if possible the key roles, and if you can do so, the responsibilities for the different people that you may have in the team assigned to work on a GDPR compliance project. What else is important in phase 3? Obviously, I talked a bit about the minimum approach versus a gold standard, and other areas that you can maybe see that are relevant. There could be even synergies that you can use with other existing compliance work that's ongoing right now. So it's important to think a bit also in terms of project management framework, governance framework. What can you put behind this project in terms of team resources and budget? So the key objectives, to summarize that, would be to deliver such a report that gives a summary on your approach after you've done the gap analysis, after you've done the fact gathering, and then try to identify practically what kind of steps you would like to take, what recommendations you see from your position for the organization to tackle, always in light of the risk assessment I mentioned earlier, to be able to then prioritize what can you actually achieve in terms of goals over the next couple of weeks or months, and what are the items that you may want to address later, depending on your resource situation, perhaps. And I would like to conclude with a couple of thoughts on not only identifying, here the slide went a bit too quick, sorry for that, going back here, the key implementation requirements, but also what's the most effective way of implementing compliance, right? Again, this gets back to every organization is different in terms of the approach and the resources you have available. So a point I want to make here is it may well be that you have to consider also other initiatives you may have on local level, regional level, or even global level in terms of compliance for data protection as a more global topic in the organization. And GDPR then for Europe fits into that and fit into that quite nicely. Obviously that will have a more holistic view to things. So we see companies, clients opting for different ways, having a GDPR standing alone project versus folding that basically into a more global approach to compliance. In terms of timing, as my colleague outlined already earlier, we think that this phase 3 should probably be in the range of 4 to 5 weeks, again, depending on how the organization decides to run such a project. But we think that's a realistic time frame in order to think about prioritizing mitigating steps, having a proper risk assessment done, and then putting a report together that then is helpful for the next steps of the project. So with that, I hand over to my dear colleague in London, Jonathan, on implementation.
Thank you very much, Jörg. Now, the fourth step is to take the materials that have been gathered in the fact-gathering stage. You have your gap analysis, and you've been through your prioritization. And I think it's clearly important to look at this holistically and then try and get a practical approach to implementation. One of the absolutely clear facts is that the GDPR will come in May 2018, and that's not long. The other certainty is that there is an awful lot to do. So this is a suggested approach to how you might look at resourcing and perhaps organizing the effort that needs to be put in. Now, we've looked at the various headline issues, and these were described in more detail in our webinar last week, and you can get the audio of that if you didn't manage to attend. And we've split it into 4 different categories. These are categorizations of convenience rather than of science, and you could do a different type of analysis if you wanted. But on the left, we have matters of formality, things that perhaps your lawyers or legal department are going to be most concerned about. The second column is things to do with accountability, the important changes that the GDPR has brought in about how data protection has to be drawn into your internal structures as a company. The third column is the family of issues that relate to the information that you have to provide, the transparency, the consents that will be very important for your data processing going forward. And finally, we have the subject rights, the important rights that individuals have over their data. Some of them are existing rights at the moment that have been modified, but others are important new rights that are going to have a cross-cutting effect on your systems and your processes. So looking at those in turn and providing a brief recap of the important issues. In the formalities, I think the first point is to look at your organization and decide where does the GDPR apply, which are the European entities that will be caught by the first step of the jurisdiction test, and which are caught by the extraterritorial impact that it has because they do business in Europe or they monitor European citizens. Next, it's important to look at the data protection officer, whether you're going to make an appointment, a formal officer, or whether you're going to do something on a more voluntary basis. Again, are you obliged to make an appointment? Next, it's important to look at each entity that's caught and see where the lead DPA is. And that's the authority that you will look to get guidance on how this new measure is going to be applied. And a lot is changing, and I think it will be very important to know where to look for help and assistance. International transfers are, of course, regulated at the moment, so this isn't a GDPR-specific point. But if you're looking at your processing of personal data over the over the whole, then I think a holistic approach will be very important. There's a lot going on in the world of international transfers at the moment. There are cases, there are political developments. And I think evaluating what you have here and being in a position where you can conduct an assessment of it is firstly very good in its own right, but fits very nicely into this holistic approach. The next topic is processing agreements. And this goes both ways. If you are appointing a processor to act for you as a controller, then you need to make sure that your processing agreement contains the mandatory provisions that the regulation applies, and also the best practice provisions, for example, an obligation to notify data breaches and assist with their resolution. Are they up to date? Are they on the supplier standard terms and perhaps could be made more customer friendly? Equally, if you are processing the other way around, then you will be offering terms to your controller clients. And again, do those take into account the regulation in its best light? Are those things that perhaps anticipate the legitimate demands that your customers may have? So those sit under the heading of formalities. The next step, I think, is to look at the second column, which is issues of accountability. And the first is how you're going to take account of the obligation to bring data protection and privacy by design and by default. So this is a very wide cross-cutting obligation that will go into your planning, your processes, and how you go about operating your business. Next, you'll be carrying out impact assessments where you carry out significant processing of personal data. So those need to be planned for. You probably need a template for doing those and a way of ensuring that they're being done in a consistent and controlled manner. Next is an assessment and looking at the legal basis of processing. This obviously overlaps with formality as well. You need, as Indini has suggested, to look at all of your personal data and how it's processed, and the basis on which that is justified. It will be one of a number of bases. And that is going to determine later the parameters of what you can lawfully do with the personal data. Documentation is going to be very important going forward. So you have an obligation under the GDPR to document your processing activities. And it's important to see how your systems and your processes can perhaps automatically do some of that and avoid it becoming an undue burden. There is an obligation to have appropriate security for personal data. And that's obviously partly a technical issue and partly relates to a legal assessment. So ensuring the data is where you think it is and it is properly protected and you're meeting the standard is an important part of this analysis that we'll carry on. And finally, there is a new obligation to notify personal data breaches, and that's an obligation to notify, in most cases, the regulatory authority, and in certain cases, the data subjects themselves, which will obviously have wider liability issues and potentially reputational issues for you. So it's going to be a very important new obligation, but we need you to have the right policies, procedures in place to record the breaches and have a response that deals with them in a satisfactory manner. Next is the new information requirements. And these are the things that give life to the general requirement under the regulation that you're very transparent about your use of personal data. So the first step is going to be to find out the privacy policies that you currently have, and they will need a thorough review to check that they give all the information that the regulation mandates that they must give to the data subjects, and also that they are sufficient to let you use personal data for its anticipated purposes. And again, the value of your databases is going to very much be reliant on the extent to which you have freedom to do this. A link point is a type of consent that you get. So in many cases, you will need consent, particularly for wider marketing activities involving personal data. Existing consents will need to be checked against the more stringent requirements of the GDPR. For example, the requirement you can't bundle consent. It may be that you need to ask for consent in more situations than you currently do. Again, those will need to be evaluated and drafted. It may even be the case that at the moment you ask for consents in situations where you're going to rely on another basis of processing, for example, to perform a contract. And there's recent guidance from the UK ICO that in that situation you shouldn't ask for consent, as it will be misleading. But all of this needs to be evaluated. If you take personal data relating to those under 18, you have to comply with the new rules on minors, and that will have an organizational implication and possibly a system implication. How do you determine someone's appropriate age and get verification if you need to do that? You'll be getting consent in certain circumstances for employees. There will be provisions in terms of employment. There will be policies set out in your employee handbooks. Those need to be consolidated and reviewed. And finally, there'll be a more general process of communication, both internally to make sure that people are aware of these new stringent rules relating to personal data, and externally it will be very important to present this in a consistent and a clear manner to your customers. And finally, subject rights. Data subjects have existing rights, and the regulation will strengthen those, and they also have important new rights. So the right of access to personal data is an existing one, but will be somewhat strengthened. It's important that you're in a position to comply with this, that you have the procedures and policies in place to make this easy. And this can be a significant administrative burden if it's not done well, so there's a business incentive to get it right. Under the regulation, data subjects have a right of rectification of their data and the right to restrict certain types of processing. You have to be in a position to ensure that this is done and you can comply. And then under the documentation provision, you've got to show that you can comply and you have complied. There's a right to be forgotten. So you will need to be able to go into your systems and with security say that at a certain point you can delete or otherwise restrict individuals' personal data. And finally, there's a right of data portability, where individuals, for example, in a social media site, can go to an alternative provider and have their information transferred. And again, there is a technical issue here and a commercial issue. It has to be possible to be done, and it has to be done at a reasonable cost. So that is a rough categorization of what we think of as the main issues. Now, you set that against the need to have resources and involvement to ensure this is done. So there's clearly going to be operational resource that's needed. You'll need to involve marketing. Legal will be involved in much of this. And there is a very real and important IT and systems component. And it may be that other aspects, for example, HR are certainly going to be relevant, other departments will be relevant. So this is going to be something that cuts across your organization. And just to draw in what we've said earlier, you will have to do all these resources, going through fact gathering, doing the gap analysis, prioritizing, and then some form of controlled implementation. So there's going to be a lot to do. Setting that against the different resources, we can look at perhaps which parts of your organization are going to be particularly involved in which different parts of this problem. Firstly, looking at IT, I've done a rough indication of where perhaps your IT and systems resources are going to be particularly interested and have a particular benefit in doing this. And I think that's primarily in the second and fourth column. So there's some practical implication of how design copes with data protection and privacy in the creation of new systems. There's going to be involvement in IT and impact assessments, and of course, assessment of security. IT is going to be perhaps the start of where data breaches are assessed. But equally, the way systems can cope with these things is going to perhaps be the key to making subject rights economic and effective and compliant with the regulation. So you'll need to be discussing how these 4 boxes on the right are dealt with your systems. Next, your operations team will probably be involved in everything, but particular points are those that I've set out here in pink. So it will overlap to a large extent with perhaps what your IT resources are doing, but with a slightly different emphasis. Marketing is going to be very important, particularly for the information section. So privacy policy on the one hand sets out your obligations, but needs to dovetail with the anticipated use of personal data and the marketing that you plan to do going forward. Consent, the way that the consent, on the one hand, the consent is a legal permission. On the other hand, if you are perhaps having a more imaginative approach to data protection compliance, you can see it as almost a form of marketing. And I think one of the things I hope is that we will see a more imaginative approach to consent, perhaps sometimes making a virtue of the information that we have to give to data subjects, rather than doing it in a perhaps too legalistic way. Marketing and marketing to children is a particularly sensitive area, so again, you'll need marketing's involvement there. And finally, any form of communication, obviously your marketing group is going to be the place that will know how to do that best. And next we have the legal group, and there's data protection is a legal thing, so you're going to expect a lot of involvement of your legal team, particularly on the left-hand side where we've looked at formalities to do with jurisdiction, the application of the GDPR, international transfers, etc. But it's also things like the adequacy of the privacy policies, the consents, the policy on children and employees. All of that will have a large legal component. And finally, HR, clearly going to be very important to how you present this to employees, whether there are issues of works councils for certain data protection projects that will be very relevant. And also one of the features of many HR disputes is that access rights are frequently used as a way of generating material for a claim, or sometimes generating an incentive for the employer to settle. So again, HR is going to be very interested in how those policies are actually framed. And putting that together, probably as close to a matrix structure as you'll get a lawyer to do, you can see that there's going to be a different mix of these disciplines for each of these particular topics. And you can probably generate, it's not a scientific assessment of who's involved in what, but just an idea to see where the potential choke points might be. So putting that all together, we know the GDPR will come in on 25th of May 2018, and I think that's just over 400 days. And that time will go very quickly. All of the other speakers have set out processes that involve relatively long periods of evaluation of information, of organization, and of gathering things together. Now, there will be overlaps, but it's rare that a project actually takes less than these anticipated timescales. On top of that, we have to recognize that 400 days is a very short time for anything that has an organizational impact or requires a change to a system. Obviously, those things in their own right take a long time, but by the time you've gathered the information, prioritized, worked out the implication, had it accepted, it may be that you actually have to go and procure resources. That will take time. You may have to make a change to a physical system. That will take time for it to be developed, tested, implemented, and then to allow some contingency before the 25th of May. So we've got a short time to do an awful lot. Leadership will be vital. We've seen this mix of different groups. It has to be led in a way that is effective and controlled. It's also very important that senior management have buy into this, and that it's not seen as something that's either a pet project of the IT group or the legal department. Data protection really has stopped being a niche area, and it's going to be something that would be very mainstream. And it's probably the penalties and the enforcement rights is the best place to start giving the incentive to get the buy-in, because this will have an incredible cost to business. And finally, on resourcing, There's a lot of internal resource, and we've seen it can come from a number of different areas. But that has to be made available. So everyone here has their day job, but how is this going to be done on top? How are people going to be freed in order to carry this out? What expert advice is required, whether that be consultants, whether that be lawyers, IT specialists. Procurement, where you need to go to the market for something, and that's going to have operational impact on you, and you're going to have to follow your own procedures. And finally, for all these things, remember the implementation lead time. So hopefully that's some ideas for how this can be organized and done in a way that's actually practical as well as compliant. Thank you.
Thank you for that excellent presentation. We'd now like to open the webinar to questions. To ask a question, please go to the chat pod located in the lower left corner of your screen. Type your question in the text box and then click on the Send button. We will pause for just a moment while questions are assembled. Jörg will be moderating our question and answer session. Jörg?
Yes, thank you, Catherine. And so we actually have the first couple of questions coming in, and I'm looking at this right now. The first one has to do, and I'm thinking who I pose a question to. First one has to do with phase one, actually, quite interesting, on fact gathering. So Undine, perhaps, maybe you can comment on that. So someone in the audience asked, how can the fact gathering phase one be tied or connected with this recording requirement about these inventories under GDPR? How do you see that from your practical perspective? Can you maybe give us some input on that?
Yes, thank you. Very happy to. As mentioned, the recording requirements under the GDPR for controllers are pretty similar to the information that should be available, for example, if you notify register data processing activities with authorities. So some sort of basic information in this regard should be already available at an organization. On top, for the GDPR recording requirements for controllers, it's necessary to provide information actually on the time limits for erasure. So this means the data retention periods. But if you have this information available, it's a good next step then to make sure that you have a suitable tool to collect this information in order to present it as a record of processing activities as required under the GDPR. And as mentioned, an Excel file is a starting point. You may think about programming your own system, or may look at tools from third-party providers. If you ask me if I have a recommendation for a third-party provider tool, I have to admit that I do not have any. There are a couple of tools out there. They all have their strengths and weaknesses. I would not say that there's a tool where I'm 100% happy with, but probably each company would have to decide to select a suitable tool, also depending on its specific needs. What is new under the GDPR, as mentioned, is that processors also have to provide for records of processing activities. So this is probably not available as information currently at processor entities. So when you are in the process of fact gathering, it's really important then for the processors to use what is required under GDPR already as a benchmarking in the fact gathering period. So processors have to really list in the records of processing activities the name and the contact details of each controller for whom they are processing, And they also have to list the categories of the processing activities they are carrying out for the controllers. They need to list the transfers to third countries, so if they use any sub-processors, for example. And they, of course, also have to provide for a description of their technical and organizational measures. So it's a good idea to start as a processing entity with that exercise also during this phase one. And maybe also from a practical point of view, what might be interesting is that the records actually of processing activities under the GDPR can be in English, so they do not have to be in the all the local languages of the EU member states. If English is a company language, but you need to be prepared once the DPA requests to see such records that you might have to provide for translations of the records.
Okay, thanks very much, Ondine. That's very useful. We have actually a related question that just came in terms of SMEs, and I think that fits probably quite nicely on these record requirements. So the question is, we have from one of the participants, what would be the impact for SMEs, and how do they have to address these vast range of requirements with lower budgets and less manpower? Which is, I think, a good question to ask when you look at different industry sectors and actually smaller companies out there. So how do they caught by this, and are there any exemptions perhaps, Ondine, in the regulation that address the SMEs?
You mean in terms of the records of processing activities?
I mean in general, and maybe there's something for the records specifically we can talk about?
There is actually an exception. At least you could think that there is an exception because the GDPR says this is not applicable to organizations employing fewer than 250 people. However, a counter exception applies when the processing is not occasional, or the processing includes special categories of data, like health data, for example. And when you look at what usual companies are doing, even smaller companies, they do regularly process their employee data, and this will include necessarily special categories of personal data such as health data. So it's really the opinion also of the DPAs. We had a discussion here with the Bavarian DPA on this topic, that this exception is hardly applicable. So you can say that also the smaller companies will be caught by this obligation to provide for records of processing activities.
Okay. We have another question on interesting the EU-US Privacy Shield from one of the participants. Jonathan, can I ask you perhaps on that one? So the question is, if a company is registered for the Privacy Shield, does it mean somehow, I mean, there's probably two questions I would think. Does it automatically mean the company meets the requirements for GDPR compliance, or is that different? Can we talk about that a little bit? And what's the relationship with the Shield and the GDPR in any way? Can you maybe shed some light on that, Jonathan?
Sure, Jörg. Thank you. I think the first point is they're separate things. So the Shield is one way that you can deal with the transfer restrictions between the European Union and America. It's not the only way, but it is one of the ways, and one of the convenient ways for certain types of U.S. organizations. So it's limited to that type of transfer, just to the States. So it's not a general solution, but it may fit a certain organizational structure. In getting Shield compliance, you'll have to make certain commitments on data protection and privacy. Now, those commitments are part of general good practice and general good privacy compliance. So when you come to looking at your GDPR compliance, hopefully a lot of what you would do for the Shield will be relevant, but it is a separate thing. So your GDPR compliance is a set of a wide range of different obligations, one of them being the transfer restriction, and one of the ways of meeting the transfer restriction is the Shield, and the things that can make you Shield compliant will be helpful to GDPR, but you still have to assess it separately. And just echoing Gina's points about SMEs and the effort of doing this, hopefully If you are a small organization, then you perhaps won't have the wide-flung processing activities that a large international group has, and actually GDPR compliance might be easier for you anyway, let alone the different exemptions that specifically apply. So I hope that's useful.
Yeah, thanks very much. That clarifies things a lot, I think, for our audience, Jonathan. And I'm looking at more questions coming in. There's a lot of them. Got to be a bit selective here, but maybe Olivier, can I ask you a question on? We talk about risk assessment and how to base a risk assessment properly on certain criteria. Perhaps can you maybe elaborate a little bit on the question on which basis is it possible to establish a risk ranking of certain action items that seems to be necessary to reach GDPR compliance? One of our participants asked. Is that something, Olivier, you can perhaps elaborate a bit on?
Yeah, sure. Thanks, Rory. Yes, indeed, and that would be on the gap analysis, phase 2, which we mentioned earlier. I think some interesting ideas for this purpose would be, first of all, to focus on the brand new requirements under the GDPR. Because, for instance, under the 1995 directive, which currently applies across EU, there was already a duty, for instance, to inform the data subjects and to provide them a certain amount of information about the characteristics of the data processing. So obviously, the data controllers should have an information notice or available, and obviously it will be updated with the new requirements of the GDPR. But at least there is already a baseline document that could be used for the purpose of establishing the new notice. As opposed to that, for instance, the GDPR creates a brand new requirement to document what is all the measures and all the legal assessments around the data processing that will be put in place, including by means of establishing the record of processing activities, which Dina mentioned earlier on. So that obviously will be a key task and should be prioritized with respect to other tasks required by the GDPR. So that's the first idea. The second one would be for each task identified, it would be practical advice for the data controller and also maybe data processors to a lesser extent to focus on the key data processing, that is the data processing involving a greater amount of data or data which are now called particular categories of data. So basically data processing that entails a higher degree of risk for the data subject. And finally, last but not least, obviously some breaches to the upcoming legal framework set forth by GDPR. Some of the non-compliance items will have a higher degree of sanctions by the data protection authorities. So obviously that is also a way of ranking the different action items that are identified in the course of the compliance program.
Okay, thanks very much for that. I'm conscious of time. We still have a couple minutes. I have one more question maybe that is useful perhaps to take into that. It's more general on ISO certifications, and Undine, perhaps that's something for you to respond to. The question is, I really think it's an interesting one for the broader audience. How would an ISO 22, I have to read this correctly, 22,000 certification help to fulfill GDPR requirements? Is that something that's useful for companies to have, to do? What should companies do about that, Undine?
It's definitely useful to have an ISO 27001 certification. Some of the certifying bodies even say it's necessary under the GDPR. I would not go that far. But the GDPR basically requires a company to take the appropriate technical and organizational measures. And in order to answer what is appropriate, you need to take into account the risk for the rights of the data subject. And in order to go through this risk assessment, of course, having a form of an information security management system like it is to be established under ISO 27001 is definitely helpful. If you have an ISO 27001 certification already, it's also now the position of the data protection authorities that this is at least an indication that you have taken the appropriate technical and organizational measures. And I think that's definitely the same also under the GDPR. And as mentioned already during the fact-gathering phase, it's definitely helpful to make sure that you reach out to IT security, and if they are in the process of obtaining an ISO 27001 certification, it's really advisable to link the efforts of establishing an information security management system under ISO with the efforts of establishing the data protection management system, which is necessary under the GDPR, because there's an overlap in terms of the security controls.
Well, thanks very much indeed. That was very clear guidance. I think our audience will appreciate that. And with that, I'm conscious of time. Looking at my watch here, we will wrap up the session for today. Allow me to say two comments perhaps on further questions that you may have. So we will certainly get back to you individually by email to answer all your questions that you sent to us in the last couple of minutes. So we will do this separately by email. And then number two is a comment on our next webinar in our series, which is going to happen in 2 weeks' time, April 5. Please mark your calendars for that. We would be very happy to welcome you back for another session. At that point in time, we will talk about GDPR in detail, and we will give an overview about different analysis of DPA guidance on local level that already came out since the GDPR was adopted, and national implementation efforts. So with that, I think we have a couple of housekeeping items left, and thanks very much for joining us so far. I turn back to the moderator.
Thank you so much, and thank you again to our presenters from Jones Day, and a special thanks to everyone in the audience. If you meet all of the criteria to receive CLE credit, you will receive an email within 24 hours. If you do not receive the email, please contact Beacon Live. This concludes today's programming.